Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 91. The podcast is coming to you with a slightly shorter gap than usual because of the fact that the last one was slightly delayed. We'll be back on track after this one until late August, which means we'll soon be at the stage where I can bang on about music festivals that I go to during the summer months. To whet your appetite, however, we'll start with a quick film review. Coen Brothers' Hail Caesar? Don't go see it, it's not very funny. Anyway, in this podcast, we're looking at three cases, of course. The first, an EAT decision which looks at whether an employer breached the implied duty of mutual trust and confidence by contacting an employee whilst she was off sick due to work-related stress, allegedly. Since this is a situation which arises quite frequently, I think this is quite an important case. Secondly, we have another EAT decision in relation to sick leave, and this case considers whether pulling a sickie, particularly over an extended period of time, can amount to gross misconduct, entitling the employer to summarily dismiss the employee. And thirdly, slightly different approach, slightly different case, an unusual EAT decision in relation to an application for interim relief under Section 128 of the Employment Rights Act 1996. Don't forget, as always, the podcast is available via iTunes, the Mayor Brown website, YouTube, and links are posted out on Twitter if you want to get hold of copies of the full case transcripts themselves. So, first case, Private Medicine Intermediaries Limited and others, and Hodkinson. This is an EAT decision in relation to claims brought by an employee who was on sick leave for apparently work-related stress. And the case, it raises a number of important questions in relation to when and why an employer should communicate with an employee who is out on sick leave. Background facts, well, the employee, Mrs. Hodkinson, was employed by Private Medicine from 2006 to 2013. She took a period of sick leave in 2013, apparently due to work-related depression and anxiety. She claimed that the reason for her depression was that she was being bullied by her manager, and the tribunal decided that she was, and I quote, very ill, unquote. And a few days into the sick leave period, the chief executive at PMI wrote to her, asking if she wished to raise a grievance, following up on a conversation they'd had before she went off, and offering to meet with her to discuss any concerns that she had. Mrs. Hodkinson replied to say that she was not in a fit state to communicate and she generally felt distraught. Well, CEO then, very sensibly, takes HR and legal advice, and then he follows up. And he writes to her on the 8th of November. And not surprisingly, this is the November letter that in the tribunal decision, this is how it's referred to. Well, in the November letter, CEO proposes to meet with her before the end of the month, and he's flexible. He says he's going to be flexible as regards the location of the meeting, but he raises 6 areas of concern that he says he wants to discuss with her. A week later, she responds, giving notice of her resignation due to a breakdown in trust and confidence, and she claimed that PMI Limited knew that she was off due to anxiety and depression, and the fact they had made 6 allegations in the November letter was intended to get her to resign. Well, she brought a number of claims in the tribunal. For the purpose of this podcast, I'm going to focus primarily on the constructive unfair dismissal claim and mention the wrongful dismissal claim, the breach of contract claim. Well, what do you think happened? Well, the Employment Tribunal upheld her constructive dismissal claim, found the November letter amounted to conduct that breached the implied duty of mutual trust and confidence, and so she was able to claim constructive unfair dismissal. And they came to this decision despite finding that PMI had genuine concerns about her and believed it was the right thing to do to raise these issues with its employee. Also, they came to this decision despite the tribunal finding that Mrs. Hodkinson had her own, quote, misperceptions, unquote, about the situation and was inclined to exaggerate. Even so, the tribunal held that the November letter had been a causative factor in Mrs. Hodkinson's resignation, and therefore they upheld this part of the claim. It's noteworthy, I should say at this point, the chief executive himself did not consider the issues he was raising were serious issues, and the tribunal came to a view that some of the concerns did not need to be dealt with at that point. Well, PMI appealed to the EAT, and the EAT uphold the tribunal findings that they had breached the implied duty of mutual trust and confidence. She was known to be very ill, she was on sick leave, potentially relating to work-related stress, and they wrote to her raising a number of concerns about things, but again, because the CEO accepted that none of them were serious in nature and some of them had already been concluded, they felt that the tribunal was entitled to come to the conclusions it did, and therefore Mrs. Hodkinson was entitled to claim constructive unfair dismissal. Well, the outcome of this case potentially places employers in a difficult position, especially given the already difficult challenge of managing employees on sick leave. On the one hand, if employers do raise unnecessary concerns with an employee who is off on sick leave, then potentially there is a constructive dismissal claim. This case is a good example. How, on the other hand, if you choose not to raise concerns, you may run into a number of difficulties in other ways. First, if the concerns are only told to the individual when he or she comes back to work, the individual could claim that they were treated in a discriminatory fashion, assuming they qualified as a disabled employee, if the employer would have raised matters with the individual sooner had they been at work, if not disabled. In addition, the employer might be prevented from raising those concerns when the individual comes back because they're deemed to have affirmed the contract of employment by not raising matters sooner. Alternatively, depending on the allegations, the employee might reasonably say they can't recollect events that happened weeks, months, even years later, depending on how long the individual's away for, and so any disciplinary process would be unfair because they're not in a position to defend themselves. But on the other hand, most employers would not wish to grant a free pass to an individual who is justifiably going to face conduct or capability proceedings, but who goes off sick maybe before that can be communicated to the individual. It's not as if we haven't seen that happen. Now, while it's generally acknowledged that an employer has a right to maintain appropriate contact with an employee on sick leave, this case raises obvious questions about what's an appropriate level of conduct. And look, clearly some measure of common sense is called for. How long is the employee going to be off for? Is the employee aware at all that there may be an issue? How ill is the employee? Is it necessary or fairer to raise the allegations now in an appropriate way or to put them off? The answer to these questions may have an impact on the right course of action. And in this case, the EAT was helped in coming to its conclusions by the fact that the employer raised no points that were serious, and the points did not need to be dealt with at that point. Certainly, the case doesn't go as far as suggesting that it will never be reasonable for an employer to contact an employee on sick leave. But it does highlight that care needs to be taken. The key point of the decision is that before writing out to a sick employee, the employer should check that it's necessary and appropriate to write, and it's only raising matters which need to be raised at that point. One typical area where an employer may wish to tread carefully is dealing with an employee who, having been notified at the start of a potential capability or conduct issue, is then absent from work with stress, thereby putting a block on the process. In some cases, the suspicion may be that the employee is looking to delay the outcome of that process or extricate themselves from their contract of employment and possibly any restricted covenants by bringing a constructive dismissal claim and possibly a discrimination claim too. In that sort of case, if you believe you're dealing with that, then clearly forward planning by the employer is absolutely key. So that's the case of Private Medicine Intermediaries Limited and others and Hodkinson. Next up, Metroline West and Ajaj, or Ajaj, I'm not sure, AJ anyway, and my apologies if the employee concerned is listening. So this is an EAT decision concerning an alleged sickie, and whether pulling a sickie, particularly over an extended period of time, can amount to gross misconduct, entitling the employer to dismiss the employee summarily. Well, you may think the answer to this is clear-cut, but certainly the Employment Tribunal might not agree with you. I picked the case because there's no doubt it is an issue that arises for employers, and sometimes employers may have suspicions about what's going on but be unable to prove it. And so this decision is useful clarification and generally, I think, would be widely welcomed. Obviously, to dismiss an employee fairly, your basic unfair dismissal. Unfair dismissal 101 says dismissal must be for one of 5 potentially fair reasons, and the 2 here are capability and conduct, of course, or possibly some other substantial reason. That's a third out of the 5. In addition, the employer has to go through a fair procedure, and if dismissing on account of conduct or capability has to comply with the ACAS code, for example, and the dismissal needs to be justifiable and a reasonable basis for the dismissal. Well, this case deals with an assessment of a test that the Employment Tribunal applied to a gross misconduct dismissal in the context of an employee allegedly pulling a sickie. The key facts, as we know them from the tribunal case, the claimant was employed as a bus driver by Metroline, apparently sustained an injury at a Metroline depot. Metroline sent the claimant to an occupational health advisor who assessed him and concluded he was not fit to drive. However, Metroline, having its suspicions about the genuineness of the claimant's injuries, arranged covert surveillance of the claimant during the period of time that he was attending work for his sickness absence reviews. And on reviewing the surveillance, Metroline concluded the claimant's account of his injuries and ability were inconsistent with the claimant's reports. Reports generated by the covert surveillance. The claimant stated, for example, he was in pain, couldn't walk quickly or for long periods of time, dress himself or carry shopping, etc. And this appeared to be contradicted by the surveillance footage. Metroline informed the claimant of its suspicions, first suspending him and subsequently inviting him to a disciplinary hearing. Following the disciplinary, he was dismissed for 1. Making a false claim for sick pay, 2. Misrepresenting his ability to attend work, and 3. Making a false claim of an injury at work. The complainant unsuccessfully appealed his dismissal, with the appeal panel, the employer's appeal panel, concluding from the evidence he'd substantially exaggerated the degree of his incapacity. Following the outcome of the appeal, he goes off to the employment tribunal. Well, the employment tribunal agreed with the claimant he had been unfairly dismissed. It concluded that although Metroline had a potentially fair reason for dismissal, it had failed to carry out a reasonable investigation. There was no reasonable belief on the part of Metroline that the claimant had made a false claim for sick pay or misrepresented his ability to attend for work. And the medical evidence demonstrated that the claimant had suffered an injury. In relation to third grounds for dismissal, the tribunal found that Metroline had no basis for concluding the claimant had exaggerated his injuries and ability to work. Instead, the tribunal judge said that a reasonable employer would have given greater consideration to the claimant's medical position when deciding whether to continue his employment. For these reasons, the tribunal held that Metroline had failed to conduct as much investigation as was reasonable, and that the evidence it was relying on to dismiss was, quote, equivocal and speculative, unquote. Consequently, the claimant's claim was upheld, although the tribunal did also conclude the claimant had misled Metroline and the occupational health advisor too, as to the extent of his injury and its effects, and therefore had a 35% contribution to his dismissal. Metroline appealed to the EAT on the grounds that the tribunal had incorrectly applied the relevant legal test, and the EAT upholds the appeal. It overturns the tribunal's decision, and in relation to whether the claimant had made a false claim for sick pay, the EAT held the tribunal had asked the wrong question. It should have considered whether Metroline had reasonable grounds to believe, based on its reasonable investigation, that the claimant had misrepresented his injury and its effect. It was not a question of establishing factually whether he was capable of walking or sitting for long periods. The EAT also held that in answering the question, the tribunal had substituted its thinking for that of Metroline's. As to whether the claimant had misrepresented his ability to attend for work, again, the wrong question had been asked by the tribunal. Instead, the question should have been whether there were grounds on which a reasonable employer could have held the belief that the claimant had misrepresented his ability to attend for work. In relation to the third allegation, and Metroline's decision to dismiss the claimant, the EAT held that an objective test ought to be applied. The EAT therefore concluded that in coming to its decision, the tribunal had substituted its own views for those of Metroline, and the dismissal had been fair in the circumstances. That's the unfair dismissal. Had been fair in the circumstances. Well, although not groundbreaking, this case is helpful. This is a helpful case. It's instructive from what the tribunal judge said, because the tribunal judge said the question of whether the claimant had absented himself from work and claimed sick pay when he was fit for work was answered by reference to whether or not he was fit for work. This, in effect, turned the dismissal into a capability dismissal. No, said the EAT, and I think they were entirely right to say so. The question of whether or not he was fit to work was not the relevant question. The relevant question was whether the respondent had reasonable grounds for believing he was engaging in misconduct. The judge also went on to consider whether the employee was wrongfully dismissed. And here, of course, the issue is not whether the employer reasonably believes the employee to be guilty of repudiatory conduct, but whether the employee actually was guilty. And the EAT judge was really pretty categorical about this, having considered the evidence. And she said, an employee, quote, who pulls a sickie is representing that he is unable to attend work by reason of sickness. If that person is not sick, that seems to me to amount to dishonesty and to a fundamental breach of the trust and confidence that is the heart of the employer-employee relationship, unquote. This is also a point raised particularly with the increasive use of social media. Employees can easily be caught whilst pulling a sickie if they are out on social media and making postings about what they're doing, who they're seeing, etc. And this case clearly demonstrates that in such circumstances it remains important for the employer to try and establish clearly what happened or what the employee is able to do before making any decision to dismiss. However, provided the employer follows a fair process and conducts enough of an investigation that they can establish their reasonable belief in the employee's dishonesty, this case demonstrates this can amount to an act of gross misconduct sufficient to dismiss. I think in such circumstances it would definitely be sensible to document the steps taken to investigate, as well as any back-to-work meetings or other meetings with the employee in question about these issues. The key question to come out of this case to the employer, the key question to be considered, is the question of dishonesty and whether the employee has lied to explain their absence, and whether the employer has reasonable grounds to believe the employee has lied. The element of dishonesty is what will potentially give the grounds to dismiss, I think. So, well, if you want to look on the other side, some aspects of the case do act as a bit of a cautionary tale for employers proposing to dismiss in such circumstances. For example, one of the doctors in this case gave evidence that amongst patients there is a recognised tendency to exaggerate illnesses and complaints, not dishonestly, but subconsciously to get to the doctor to get their point across. Also, on the point of covert surveillance, it's often important to remember that it will only take an employer so far in its investigation. Often more than surveillance will be required to demonstrate reasonable belief that an employee is acting dishonestly, particularly with mental health or illnesses, where the state of the condition can vary at different times. Equally, this case is a clear reminder to employers to ensure that they have clear absence management and or sickness policies in place, and to hold back to work meetings with employees who've been off sick. It's always worth employers proactively managing absence. Meetings with the employee concerned and obtaining medical evidence is usually advisable, if not essential. The helpful message to come out of this case, though, is if suspicions can be substantiated and the evidence is enough to satisfy the test of reasonable belief of the employer, then the employer may be in a position to dismiss on the grounds of gross misconduct. So that's the Metroline case. Third and final, Parsons and AirPlus International Limited. What do you know? It's another EAT case, but it's on rather different things. So this is an application for interim relief under Section 128 of the Employment Rights Act. Brief legal background, because a lot of people haven't come across interim relief applications. Where an individual makes a complaint under the whistleblowing legislation, they can also apply for interim relief under Section 128 of the Employment Rights Act 1996. Tribunal hears that interim application, and if it appears, according to the legislation, that the claimant is, quote, likely, unquote, to win the final case, it must make an order for interim relief. The outcome of such an order is the employer must continue to pay the employee pending the determination of the tribunal complaint. Importantly, there's no provision for repaying the costs of an interim order in the event that the claim ultimately fails on its merits. This makes the interim relief application a nuclear option for employees and can be an early and very significant tactical win right at the start of the litigation. However, as this case indicates, the bar is set really quite high for such a claimant. So, Ms. Parsons, employed by AirPlus International in August 2015 as a compliance manager, dismissed only 5 weeks later with immediate effect. AirPlus International say the reason for her dismissal was, quote, cultural misfit, unquote, and it claimed that she behaved inappropriately and in an aggressive manner towards her colleague, which made the workplace environment uncomfortable. Ms. Parsons argues that she had in fact been unfairly dismissed because she'd made protected disclosures and therefore ought to be given protection under the whistleblowing legislation, and she applied for interim relief under Section 128 of the Employment Rights Act 1996, and we end up in a hearing. Now, let me say at once, the case continues, so there are no absolute findings of fact as determined as yet by the court. Well, the tribunal rejected Ms. Parsons' application for interim relief and held that although she had, quote, a good arguable case, unquote, she could not show that she had a, quote, pretty good chance of success, unquote. The tribunal held the matter was not clear-cut and that ultimately it could not rule at this stage that Ms. Parsons was likely to succeed. Therefore, her application for interim relief was refused. Ms. Parsons appeals to the AT. The AT dismissed the appeal and agreed with the tribunal that Ms. Parsons could not prove at this stage that she had a good chance of succeeding. It's not for the tribunal or EAT to make detailed findings at an interim stage, and they are only there to assess the chances of the employee succeeding. So, we rarely have cases on the interim relief procedures under Section 128, so the case is, if nothing else, a useful refresher. The test for interim applications of this nature has been, for some time, the claimant needs to show that she has a, quote, he or she has a, quote, pretty good chance, unquote, of succeeding. It's useful to have the confirmation this sets the bar higher than a, quote, good arguable case, unquote. Now, generally, I think the decision will be a welcome one for employers, as it highlights the relatively high hurdle that claimants have to get over in order to be successful. Even though an employee may have some strong arguments, that may not be enough for them to reach the necessary threshold of being deemed to have a good chance of success overall. This is, of course, especially welcome news for employers who would otherwise face a large and unrecoverable cost if the application were to be successful. I think the one downside, however, is the EAT was very clear that the course adopted by the Employment Tribunal in this case had been a sensible one, that no oral evidence was given at the interim hearing. The judge read the witness statements. The judge was required to make, according to the EAT, a, quote, summary assessment, unquote, of the evidence. Didn't need to make a summary determination of the claim itself, because the judge's decision at that interim stage would inevitably be a matter of, quote, impression, unquote. So this seems to give the tribunal judge hearing this interim application a fair measure of leeway. We might see claimants chancing their arm, especially if the litigation would otherwise be hard-fought and lengthy in these circumstances, because what's the worst that could happen? The judge says you've got a case, but it's not enough for me to be satisfied, and on we go. So that's the case of Parsons and AirPlus International Limited. So thanks very much for listening. I'm off tomorrow to the Mayor Brown Partners Conference in Scottsdale, Arizona, which is a conference we do every 2 years. So assume I get back safe and sound from that. I look forward to speaking again in a couple of weeks' time. I think it only remains for me to say that, as usual, we intend that no partners are harmed or mistreated in the making of the Mayor Brown 2016 Annual Partners Conference. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.